All right, it being just now after 7 o'clock, I'll call today's Zoning Board of Appeals meeting to order. The first administrative item we have involves the minutes. In front of you should have a redlined version of the minutes from February 2nd. I think the red lines are from Andy's comments that he submitted. Andy Morse, sorry. And then we have the minutes of February 17th that could be distributed beforehand or in front of you as well. So that one might take a little bit more time. Yeah. I think in light of the other items on the agenda, we want to make sure we go through that carefully. All right. So with respect to the minutes of February 2nd, any comments or edits on page 1? There's a small inconsistency between applicant being capitalized and applicant not being capitalized. So as long as we can pick one of them, and maybe it's just on page 1, but it just happened to be that way.
On page 2, and if God moved to waive the notice of public hearing, no, the reading of the notice of the public hearing. One of the most fun things I do.
We got to do it again soon.
Very practice.
Yeah. Sorry, I can never wonder. Do we need to indicate that when we, I know it says listed as a members participating. Do we need to have a formal line from the next 24? Is it? Okay. Anything else in pages 1 and 2? On page 3, about 2/3 of the way down, the paragraph that starts with Brian Birch claims that any person who rents out, that one. In the last line, you have he states. I think everything's going to be passive voice, so it should be he stated. And then the next paragraph, Massachusetts Supreme Judicial Court. And then the last paragraph, yeah, I don't know, maybe we'll read it. Says they have not applied for special permits. Why I could say for any special permits or for a special permit. For special permits on this implies I think, yeah. Otherwise it implies that they should be applying for many. Yeah.
So, David, just to put a fine point on where you corrected the he stated.
Yeah.
There's a few other points here where we say, oh no, I guess it's consistent. Sorry, got it. We're good. Thanks.
Actually, in that last paragraph, technically the owner is a company, right? So shouldn't owner be single? Even if it's two individuals owning the company? Yeah, okay. You may want to just check for consistency on that point. page 4. If anyone's got the stuff on pages 1 through 3, just please speak up. 3/4 of the way down where it says Brian Birch stated that allowing, that just reads weird, it's funny. Brian Birch stated that allowing one sober living in home.
Get rid of in, so one sober living home will cause others to be established.
Okay. Obviously I don't remember. You watched it more recently than I did. Did he mean to say, was he saying stated that allowing one sober living home in town? Or not?
Yeah.
Okay.
That's what he meant.
That's what
in
he
the neighborhood.
Right.
Would encourage others.
Okay. Yeah. And the last sentence. He added that if 41 Birch Hill Road is limited to 4 residents in recovery, it will incentivize the purchase of other homes along the street. Was it incentivize the purchase by the same owners, or?
He didn't clarify that.
Okay, that's how it came out.
That's what I would assume he implied.
Yeah, well, if that's how he said it, then let's keep it. I mean, that's how I understood it too. So, okay. I'll just take the opportunity to flag page 5. Like I said, just I have notes.
Are we on page 5?
You can take your time. I just have some notes,
Oh, okay,
so I
sure.
figured I'd give it to Michael while he's still. Third paragraph under board questions and comments. David Hardinale asked the applicant for more information about. Maybe it's because of me, so I'm remembering. I thought I said it this way. Instead of what actually happens, I think it's what is actually happening. And then there's a paragraph down below that starts with one goal or hypothetical.
So I was going to mention the typo.
It's not hypothetically, it's hypothetically. The Len Golder paragraph.
It's a typo.
So that's a new word. That's one word too. And then third full paragraph from the bottom, the big one that starts with Ernest Dodd. Right in the middle, it says he stated that the use does not align with the boarding house. I'm pretty sure, to keep me honest here, I think he stated that the use does not align with the definition of boarding house.
The next to last line, we have the furnace to that function Tuesday. The
Oh, I was thinking
terrible.
What was the edit?
his first name, next to last line. Page 6. Second paragraph from the top, again, just a tense consistency. It says he emphasizes, and so he emphasized. Then, with respect to the bullets from Mr. Pavlov, Fifth bullet down, I think it's 3 months of video footage. I have it as well. I have it as well that he specifically said that he can see inside the house and there's more than 5 people living there. If you want to go back and check out, just because it's an important point, I need to like
I can double check that.
yeah, if you could. Yeah, because that one, I don't know, that one stuck out that you can. It was inside. It's so close you can see in the house.
He did say that.
Yeah, and then 1, 2, 3, 4, 5, 6, 7, 8, 9. So the 9th bullet down, but the yes or no arsonist would be allowed to reside in the sober home. My recollection of that is that he said he spoke to the manager or whatever. I don't know what the person's called. They said he spoke to the manager, who reassured him that there would be no arsonists. He mentioned the second crime. I can't remember what it was, but maybe we can go back and check on that. So it being 7:15 right now, why don't we just pause on the administrative items and move to our scheduled public hearing for 142 Red Acre Road. There we go. All right. We've got 5 voting members tonight, so that's great. Also entertain motion to
Waive the reading of the public notice.
Second.
do a motion, we have a second. Any discussion? Hearing none, all in favor?
Aye.
The reading of the notice will be waived. So we will begin the public hearing for the application for a special permit of 142 Red Acre Road. In just a moment, I'll have you folks provide just a brief presentation. We obviously have your written materials already. Please feel free to provide any additional information if you want, anything that you want to emphasize, let us know. During the course of the public hearing, both members and associate members are free to obviously ask questions. This is Stow, nothing further.
Should be back.
Okay. All right. So picking up where we were before, after your presentation, after we ask some questions, I'll open it up to public comment to the extent that anybody here who's present tonight or anyone that's on Zoom wants to make any ask any questions or provide any comments, whether they be in a butter or not. Just to be aware for the members of the public who do wish to make a question, ask a question or make a comment, and I'll go over this again in a little bit. Make sure you state your name and your address. If questions are asked, they should be made to the board and not to the applicant. To the extent that there is a question that you would like to answer, you're welcome to. If you rather not answer the question that a member of the public asks, you have absolutely no obligation to do so whatsoever. That being said, if the board decides to adopt the question and then ask it, then we would look for a response, but otherwise you don't have an obligation whatsoever. After that, we'll sort of continue our discussion with you all. When that is done, we'll close the public hearing, move to our deliberation, and thereafter, if ready, vote and then proceed with the decision. So with that, I'll stop talking and turn the floor over to you.
Wonderful. All right. Well, I'm Brian Joseph. It's my wife, Angela. We are the owners at 142 Red Acre Road. And we come to you today because we'd like to build an addition to our house. We'd actually gotten a special permit to build a house in the first place in 2017. So being a non-conforming lot already, we knew we had to go through this process. In addition to that, we would like to extend into the setbacks, primarily because we didn't get to choose where the house got built in the first place. We built on a pre-existing structure. We're looking to add a two-car garage, a mudroom, an office, wood shop, a family room, and a sunroom / greenhouse area to grow, along with like a small outdoor deck area. So the new structure will be 28 by 40. As per the permit plan, there'll be a small deck off the back. There will be basically an attached mudroom that connects the existing structure to the new structure. So.
All right. Questions, comments, thoughts from the board? Andy?
Well, I mean, looking at the plan, it is clear that you could redesign this so you don't have to go into the setback. Have you considered doing that so you wouldn't even need a special permit?
Well, so I assume that we would still need a special permit, despite because we're on a pre-existing non-conforming.
I don't know, is that a good
Is that
question?
correct?
Yeah, okay. Yeah,
So,
it'd be easier.
Yes. Yes. To your point, so if we move the structure into the backyard, it takes away from landscaping and everything that we've already done. We're currently having to take down one oak tree that's next to the property. We would have to take down a second oak tree if we move the structure back further.
Right.
And then in terms of moving it into the front yard, we have our septic to contend with.
Right. Well, I'm just looking at, looking at the design, it looks like you're little 6.5 into it.
Yeah.
You have, again, this would destroy your basic design, and I understand that, but it's just, if you would move the garage closer to the house, you'd be within the setback.
Yeah, I mean, we considered keeping the garage to a smaller size, and it's with what we want to accomplish in terms of storage and the size of the mudroom. I mean, the other thing is, we could redesign some of the roof design, but I was trying to keep the garage away from the primary house, just in terms of having a cross gable, like perpendicular to the existing gable of the roof. We would have to basically extend the current roof of the house over and interconnect. We want to add some glass roof on the garage itself to provide like a growing space and a sunroom. So it changes a lot of the design elements. So I mean, that's where we.
And again, I'm just understanding your process and determining this and trying to decide, is there a way to make it?
And it was one of these, an inch here, an inch there, and suddenly we're 6 feet into the setback kind of design process.
Other questions, comments, thoughts?
I see it, where the septic is, it's nowhere near the septic. What about the well?
The well is in the backyard, so essentially, I mean, looking back here, the well is quite a ways away. So basically, where, like on the site plan, where it says lot, is fairly close, or maybe closer to the E in area.
And in terms of your butter, is that the smart land? Is that what?
Yeah. So it's a flag lot to the Affordable Housing Trust. So this lot that continues down, and presumably eventually there will be a road through here. but it would be on the, basically coming along our property line. There's an existing utility pole that's right here as well, anyway. It's about like 10 feet off of, so it's a probably 4 to 8 feet into our property. So that would be where presumably the road would go through.
What's that squiggly dashed line there in that road to be? What does that represent?
I think that's just really the cleared out path that goes, because there's an area where there's it's just like small vegetation that goes through where there's not as much forestry. So right now there's walking paths that go up there.
If you drove by there, which I didn't do, I went to Google Maps and drove by, but the house on the next lot over is basically will be a mirror image of what he has.
Mhm.
They have the garage is on the property line side where the easement goes through, and they're quite a ways away as far as it's kind of balanced.
The Polans.
Yeah, the whole
Yeah.
Can we just pause there for a moment? Any comments from staff, Michael? Your thoughts?
The only comment I have is that there is that 12-foot easement along the northeast side. So it could be something the board would condition to just add that to the site plan prior to the building permit, just so we have one plan with everything on it. Just makes record keeping easier for us and the applicant and future owners. So that was my only comment.
All right, well, just further pause and see if there's any public comment. We'll start with folks in the room. Just a reminder, if to state your name and your address. So, anybody in the room have any public comments, questions, concerns?
Any abutters?
Took away my next question. So,
You want the job?
please take it. Is there anyone online who has any comments or questions? If you do, oh, I see someone waving. Okay, if you can unmute, and then
Mike, you're unmuted, so you just say your name and address.
Sure. My name is Mike Kopczynski, 12 Canterbury Road. I'm speaking on behalf of the Affordable Housing Trust, which is in a butter. And we have no objection to what folks want to do. And we just want to, again, note that there's that easement that Michael mentioned. And whether it's on the plan or not, we just want to make sure that there's no impact on it. We talked to the developer that we've chosen for the project, and he looked at the plans and didn't think that there was there would be any impact. But I think, Michael, it's a good idea, as you stated, to have it clearly written out there so that it's clear on both sides what's going on. But besides that, there's no objection.
great, thank you, Michael. Any other comments or questions from folks online? If you do, you can virtually raise your hand. Or press the button saying you're raise your hand.
Start waiting.
Or start waving either.
There's no others.
No. All right, great. Any other questions?
How close is the edge of the garage to the easement?
It would be about 6.5 feet from the edge of the garage. Yeah.
Any other questions, comments, thoughts from folks on the board? No, Michael, anything?
No further comments.
Move to close the public hearing.
Second.
We have a motion, we have a second. Any discussion? Any additional comments or information that the applicant wishes to provide?
Great to hear from the affordable housing folks. Didn't actually know that there was a contractor involved, so that's very exciting.
There we go. Nothing else? All in favor of closing the public hearing? All right, and with that, the public hearing is now closed. We can no longer take information from the applicant or members of the public, whether it be for or against. And I will open the floor to the members for their thoughts.
I think that, there doesn't seem to be any problem or objection from, the abutters. I think, Smart's indicated that as long as, there's no impact or the developers talk to them, it shouldn't be an issue. So it seems fine to me.
Any other thoughts? Any concerns?
I would agree with what Lenny said.
Yeah, I'm fine.
We can. I'll entertain a motion.
I move that we approve the, grant, the application for a special permit for 142 Red Acre Road as identified in the application.
Second.
I have a motion, second. Any further discussion? Hearing none, all in favor?
Aye.
All right, and with that, special permit is granted. Do we have a draft decision?
Yes.
Excellent. Just pass it.
I noticed one typo immediately. It's the applicant's name.
The only thing worse than the typo of the address is the name.
Yeah, you didn't swap the I and the A in my name, so that often.
That one's not gonna get caught by a spell check.
Yeah.
So,
Wonderful.
all right, let's take a quick look at the draft decision.
So.
Finding the board number 4. There's a hyphen missing in the word non-conforming. Any other edits, comments, concerns, additions, deletions in the draft decision? And I do note that, Michael suggested about the utilities and being shut on the site plan is listed as, commission approval. That's already there. Yeah.
I'll move we approve the decision for 142 Red Acre Road.
Second.
All right, we have a motion, we have a second. Any discussion? Hearing none, all in favor of accepting the draft decision as modified?
Okay.
All right, and with that, you're all set. Decision will have to be, once Michael makes the small sort of typographical changes, it'll have to be recorded, wait 20 days for the appeal. And then, do you have any other questions? Just talk to Michael and the folks in the planning department. You'll be all set.
Wonderful. Thank you so much.
Thank you.
Good luck.
Good luck.
Your previous application wasn't as easy, was it? Kind of fits right in. That's right.
All right, we have our ongoing deliberation of 41 Birch Road. Before we do that though, can we see if we can just finish off the minutes February 2nd, just as we're sort of in the midst of that? And then I think I've got with edits to pages 6 or 7. If anyone has older edits, don't feel like you can't, go.
There's something here. On page 9, can I mention something on page 9?
Yeah, absolutely. Yeah.
Please. Let's see, 1, 2, 3, 4 paragraphs up from the bottom. It has to do with, my comments. Noted 41 Birch Hill is a commercial use. I don't know if I said that. I didn't mean that. If I said it, what I meant was a commercial entity. I know we had a big discussion at the next meeting about the difference between a use and an entity, and I was trying to emphasize the entity.
I'll go back and check.
Okay, thanks. And it says has transient, appears to have transient occupants, because we don't really even know for sure.
I make a motion that we approve the meeting minutes of February 2nd as printed.
Second.
We have a motion, we have a second. Any discussion? Actually, I have one. I'm sorry. I was just about to say it, then you're gonna, sorry, this is really quickly. On page 10, the adjournment. Oh, was it really just 4? Oh, because that's right, because Andy wasn't here. So that's right. Okay, never mind. The only thing I want to ask is just because Michael said he was going to go back, I think, to check the recording on a couple items, we want to wait
Oh, yeah, okay.
until
If you
we,
want to validate those.
just to double check those.
Sure, yeah.
Okay. Well, technically we have a motion with a second, so,
I withdraw my second.
all right, the second has been withdrawn. Any second? All right, hearing none, the motion is moved.
Okay.
Okay, all right, so, in that case, Michael will go back and just double check on a couple of those items that get flagged. And then, if you could just maybe do us a favor, once you update the minutes, for the particular ones you have to flag, if you could just maybe like highlight those, either to indicate that you've added something or you realize that something that was suggested here was wrong based on our memories, just so that we know. And then we can review those and actually vote on those at the next meeting. All right. We have the draft minutes from February 17th that we could go over right now, but I think our time might be better spent immediately to talk to town council, who is here. Hello. Unless you had something that you had prepared to say, which I don't think you did, I was frankly just going to open up the floor for folks to ask council questions in order to support our ongoing deliberations with respect to the appeal on 41 Birch Road. Should we just open the floor? Sure. Okay. All right. Thank you. So I'll open it to the members to ask any questions.
Yeah, I go.
Yes. Okay.
This whole issue, in terms of the Americans with Disability Act and how we should treat people with disability, or treatment. In terms of who we can compare people with disabilities to, is it just to people who are in a residence that are non-family members versus family members? Does that make any difference? In other words,
Sure. So I don't know that it's much comparing. Essentially, General Law Chapter 48, Section 3, which has a lot in it. There's a lot of different sections. Has specific protections that apply to disabilities and disabled people. So there's a provision in the statute that says that for local land use, health and safety laws, regulations, practices, ordinances, bylaws, and decisions of the city or town shall not discriminate against a disabled person. And then it goes on to say, imposition of health and safety laws or land use requirements and congregate living arrangements among non-related persons with disabilities that are not imposed on families and groups of similar size or other unrelated persons constitutes discrimination. And that language has been difficult to use and has been difficult to apply. And very recently, we got some clarification on that language from the SJC in the Bach case, which I know has come up in your conversations. And what the SJC clarified in that case, and I'll read it to you because I think it's pretty clear what the SJC said, and I think it goes to answering your question, is that the statute entitles disabled people to be treated the same as non-disabled people are treated under the local ordinance. Thus, if a group of disabled people living in a congregate living arrangement meets the definition of family, in this case, under the local regulations, then it's entitled to be treated as such. Likewise, it's entitled to be treated as any similar group of non-disabled, unrelated people is treated under the local regulations. And this gave us some good clarification because the statute says congregate living and families, and we've always, as practitioners, recognized that those can be different things, so how can it be both? And what the court is saying is it doesn't have to be both. Folks that live in a sober home are entitled to the protections, they're entitled to be treated the same as any other use that they're making under your bylaw. And so it does get a little confusing, and sometimes it gets kind of mixed up with the Dover Amendment, which is nonprofit educational uses, and that's not what this is. So this is a different section of the statute, and what it's simply saying is that disabled persons have a right to live in the community like anybody else and be treated the same as anybody else. And so it doesn't matter if the home is owned by a company, it doesn't matter if it's owned by an LLC, it doesn't matter if there's a commercial component, that's not the issue. The individuals in recovery, sober people, are considered disabled under federal law, and the FHA and the ADA and all the protections that attach to disabled persons attach to them, and the courts have also extended those protections to the sober homes themselves. So you have to think of a sober home as having all the same legal protections as a disabled person. And so there isn't a distinction between the home being corporate or commercial or anything else and the people that live there. People have a right to live within the community. So here, and I know the Bach case talks about family, here, the town zoning bylaw does not have a definition of family. The town zoning bylaw has single family use on your use table and a definition of dwelling unit. And it's my understanding that a single family home for zoning purposes in the town of Stow is a single dwelling unit. That's how it's defined. And so you have the definition of dwelling unit, and your definition of dwelling unit is one or more rooms for cooking, living, sanitary, and sleeping facilities arranged for the use of one or more persons living together as a single housekeeping unit, but not more than 5 persons unrelated by blood or marriage. So you're not really comparing per se, it's just that you allow, essentially, in a single family home, 5 unrelated people to live together as a household. And so if 5 friends can rent a house together from a person or a company, then 5 individuals can live in a sober home together, regardless of how it's owned or operated. And so really you're just comparing the use. So for example, if you had a sober home that wanted to have 8 people, you would say, well, that's not operating within our definition of dwelling unit. But it's really just the same as what any other 5 persons who are unrelated by blood or marriage could.
So if it was more than 5, then there would be a restriction because of the zoning bylaw.
So
just like with any other group.
Yeah, exactly. So in my opinion, if you had, 8 friends that wanted to live together, you'd say, hey, you can't live together, you can't be unrelated people in one dwelling unit. That's not how we define it, and you would apply this exactly the same. So it's really applying it exactly the same as you apply it to anybody else.
Yeah, and we don't define family anyway, but even if we did, from what you read from the SJC, I don't think it really makes much difference
So
in terms of how you treat a family versus a non-family group anyway.
Well, the Bach definition of family had a similar kind of dwelling unit definition that you have, but you don't have a definition of family, so you can't apply it it's not in the bylaw, it can't be applied.
Yeah, but if it was, I mean.
Okay, so it would depend on what it says, but, I don't think in general, the way that our statutes get interpreted, courts are careful in not interpreting bylaws and statutes to nullify legal provisions. And so, the bottom line is the statute, as well as federal and state law, which kind of supersede your zoning, they come over your zoning. Contemplate and provide protections for individuals to be able to live within residential neighborhoods in their communities.
So if we, were to ask for a special permit, like the building commissioner suggested, for example, and, if the, we just didn't, come forward to apply for a special permit, where would that leave us?
Well, so I don't think the building inspector suggested a special permit. I think the building inspector said that he was operating under the definition of dwelling unit and informed the operator or the owner of the property that they needed to use it consistent with that definition. So just to clarify, I think that's what the building commissioner did. So he said, based on the discussion with the operator of the sober home, I'm using the definition of dwelling unit from the zoning bylaw, and then he went on to say the owners have been informed of this. And then he said if they wish to have more than 5 people, they have to apply for some kind of approval.
Okay.
But just to have 5. Yeah, and that gets a little tricky because, if you're applying for a special permit, it has to be for a special permit use in your bylaw, right? 48(9) says zoning bylaws can have categories of uses that are allowed by special permit. But in order for someone to apply for and obtain a special permit, it has to be for a specific use. So you would have to look at the use table to see, what, if any, special permit was available for some other type of use that might accommodate this. And then there's the added ability for a sober home and the disabled individuals of any sort to ask for reasonable accommodations. So something else that you see in the Bach case is actually that the board did grant certain reasonable accommodations to allow the home to operate a little bit different than within the zoning bylaw itself.
Okay, so as a practical matter,
Yes.
if we don't know how many people are actually in this sober home, there could be 5 or there could be more than 5, but we don't know. So what does that leave us with in terms of what we could or should do?
Yeah, I mean, this one, where you haven't heard from the operator of the home at all, it definitely, in my opinion, puts you guys in a bit of a tough position because, you haven't gotten direct information from the folks that probably have the best direct information. Anytime somebody is seeking zoning enforcement, whether it's a building commissioner or an abutter or whomever, they actually have the burden of proof to establish as a zoning violation. So that's something to keep in mind as you're evaluating this. Unfortunately, you're going to have to evaluate it based on the information that you have. You kind of have 2 things in front of you. From my perspective, you have a legal question and a factual question. So, it's possible that you might ultimately say, we're going to uphold the building commissioner because we agree that a sober home could operate in a dwelling unit, but perhaps with some order or direction to the operator to provide documentation, that they are operating that way. Or, it's however you want to handle it, but definitely, I think you're in a bit of a spot because you don't have a full record, which is not obviously your fault anyway.
So just to follow up on
Sure.
the reporting aspect of this, so we have no way to ascertain how many people are in the facility at any particular time. And I think in the case where you described it, most of it would be an after the fact kind of an event because there's no real requirement for them to get any permission to do this. You can stand one of these things up really on your own and there's no guideline that says you can or you can't. So you can either have one that may be sanctioned through the MASH, which would,
It's voluntary, yeah.
but even then, there's no teeth in how they actually administer the operation. So you got something that's in place. You may or may not have a situation where you think something's going on. How do you actually go about dealing with something like that? So if there's, we say 5, they've got 7 or 9 or whatever the number might be that's over the limit. How do you deal with that?
So yeah, I mean, it's definitely challenging. If ultimately you have a comfortable level of factual proof that there is a zoning violation and it isn't cured, then normally, I mean, it's more hypothetical, normally the next step would be to get select board authority to go to court and ask us to go to court and ask the court to enforce some kind of zoning issue, some kind of court order to bring it in check. We usually like to see a pretty good level of evidence that there is an actual zoning violation. Unfortunately, that goes forward, but it really becomes, unfortunately, an issue of enforcement.
Can I ask? Sorry.
Yeah, no, that's okay.
Not to be legally technical here, but when you say a comfortable level, and obviously the burden is on the applicant. Is it like 50% plus one, more likely than not?
Well, and that's a different question though, so for your purposes now, anyone seeking zoning enforcement, the burden's on the applicant.
Right.
If going forward, there's a new situation where there's new violations or what have you, and, your building commissioner reaches out and says, it needs to be operating, 5 or less, this is the evidence that I have. Ultimately, when we go to court on zoning enforcement, we ordinarily ask for a preliminary injunction. So in order to get a preliminary injunction, you either need an affidavit or a complaint that's signed, essentially like an affidavit under the pains and penalties of perjury. So we're always looking for evidence that someone from the town is comfortable to sign off on that
Right.
standard.
But in terms of the burden on the applicant, is it, like, there has to be some sort of a level, it can't just be like, well, I'm saying this and that's good enough, or maybe it is, that's what I'm saying, like, it's more likely than not, as opposed to some outrageous, clear and convincing,
There isn't a ton of guidance for you as a board.
I know.
On how to credit the information that you receive. You receive it and you credit it as you credit it. And partly that's, why when there are zoning appeals to court, it's a de novo review, right? Because you go to court and that's where there's an opportunity for discovery and fleshing out real records and facts, and you don't always have that.
You may want to explain what a de novo review is.
Sure, so the way the zoning board decisions work, which is different than, for example, like say, some of the Board of Health or Conservation Commission decisions, is that you make a decision based on the information that you're given, and if somebody appeals it to court, the courts hear de novo anew. And what that means is that the court will actually find the facts based on the evidence presented to the court, not on the record before you, it's not a record review. And the court will decide based on the facts as the court finds them, is your decision supported? By contrast, some of the Board of Health decisions, a lot of the Conservation Commissions are a record review. So literally in those cases, when there's an appeal, the town prepares the record that was before you, that gets filed with the court, and that's all the court's gonna decide it off. And so there's definitely an understanding in the law that a lot of what comes before the zoning and planning boards, it would be somewhat unduly burdensome on applicants to require them to flesh out the same level of documentation, even from a planning, engineer, expert kind of standpoint that you might ultimately need in court. And so the standard for your appeals are that the court is going to find all of the information based on what the court has before it, which often includes more information than what you have. Yes.
Yeah, I just wanted to see if you might want to clarify whether the burden of proof is truly on the applicant as an individual, or if comments made during a public hearing could be added to that burden, that proof.
Yeah, the burden of proof is on the person seeking zoning enforcement to convince the board that there is a zoning violation. I don't see any reason why, it is a public hearing, so I don't see any reason why the board can't credit whatever information it gets at the public hearing to make its decision. And the same would go with the building commissioner was bringing it. You have a public hearing, the public has spoken, you have all that information in front of you.
Since they're licensed in the state, or they have, is there any way we can get the Attorney General or the Department of State to help us with this issue? Because they're not showing up in our meetings. They've been told about the meetings. They chose not to appear before us. Is there any way that they can be forced by the state to abide by our bylaws and do what they need to do to file the applications and get approval, or even disapproval if they're...
Well, again, I'm not sure that so there's no mandatory licensing for sober homes in Massachusetts. There's a voluntary kind of association you can join. It's called MASH, it's the Massachusetts Association of Sober Homes. So there is no state involvement.
Basically no control over whatsoever by the
Either
state.
way, no,
But-
it's voluntary if you do go with the MASH route, or you can just start tomorrow
I've never
morning.
seen that.
Yeah.
But then again, even if there was, again, this is an issue of local zoning, subject to how state and federal law apply to it. And so again, if there was evidence of an ongoing violation, for any operator of an ongoing violation that they were not voluntarily curing, the next step would be an action to court.
On the issue of the owner's participation. Am I correct that under section 15, I am the capacity as chair can actually summon witnesses and therefore could summon the owner or the representative to appear?
I've never seen a zoning board summon someone. I will say your public hearing is closed,
Understood.
so.
We can always reopen it.
I'll be honest, I have never,
The only reason I'm saying is because I was reviewing it today and it says the chairman or in his absence, the acting chairman may administer oaths, summon witnesses and call for the production of papers. But I want to make sure I'm reading the right part.
no, I mean, it does say that, but again, I have never,
I couldn't find anything beyond that.
I'll be honest, I don't think when it says summon witnesses that is intended to mean that you can issue summonses.
Okay.
I think it means you can ask
Call.
them.
Ask for people to come and
Yes.
talk and things like that.
Yeah,
I mean, I'd seen in I think some other bylaw in a different town where they actually addressed it, and I think actually even when, basically gave the ZBA some right to do it. We obviously don't have anything like that here, nor did I find it that, I just figured I would ask because I saw that and sort of caught my eye.
I see that it says that. Like I said, I have never had a zoning board try to use that authority, but off the top of my head, I say you probably don't have the authority to formally summon witnesses.
All right, let me ask one other question, which is, obviously, we have a zoning enforcement decision, technically actually two, before us.
Yes.
We can affirm. We can grant the appeal and reverse the decision. We can deny the appeal and essentially affirm the decision. Can we remand the decision?
It's interesting. So 4814, so General Law Chapter 48, Section 14, governs the powers of the Board of Appeal. And one of the things that it says is that you can obviously hear appeals under 48.8, which is what you're doing. And it says, in exercising the powers granted by the section, the Board of Appeals may, in conformity with the provisions of this chapter, make orders or decisions, reverse or affirm in part any order or decision, and that you have all of the powers, essentially, of the building commissioner when you're acting. And there isn't a lot of guidance on what that means. So I will say in most instances, we don't really see it as a remand or an order to the building commissioner. We see requests to the building commissioner. I certainly think that you have the ability, like I said, for example, if you were to say, we agree on the law with the building commissioner. We agree that a sober home may operate as a dwelling unit in our town if they're operating within the definition of dwelling unit. And then I think you could order the operator of the dwelling home to provide, documentation that they are in fact operating within that definition.
Yeah, the reason I ask is because obviously I keep going back to reading the zoning enforcement officer's decision.
Mm-hmm.
He states his understanding of the law with respect to dwelling and boarding house. He says that he informed the owners of that.
Yes.
And then that's it. Doesn't actually say he doesn't actually say they're in conformity or they're not. Simply, this is what the rule is, what the law is,
yes,
and the bylaws are. I told them that. Yeah. And if you're aggrieved by that, let me know. And so it struck me in preparation for this for today's meeting that it almost seems like he may have fallen like one step short. It's like instead of saying like I told them what to do and I have determined that they are currently not, or that they currently are, or whatever it might be. And so I almost, that's why I was wondering, is it possible for us to remand it back to them and say, no, you have to say yay or nay, and then we decide?
Yeah, I wouldn't really see it as a remand as much as more of an order to the operator to provide the building commissioner with that documentation, and then the building commissioner could take it from there. I obviously can't speak for the building commissioner, but
Of course, I'm not asking you. Yeah.
No, but I think it would be fair to read that as saying, I talked to them, I told them what they're allowed to do. I'm comfortable with what they're doing because I'm not taking any more enforcement action. But that's just my read of it.
I understood. I guess I'm a little hesitant about reading too much. I mean, it's like it says what it says.
Absolutely.
And I'm also being sensitive to the applicant who is facing the appeal off of what was written. You know what I mean?
Yeah.
And so I figured I would ask that as well.
So in other words, we could though ask the building commissioner to be a little bit more definitive In other words, rather than just saying, this is what I told them, in other words, to actually ask him, did he make a determination whether or not they were in compliance, as opposed to his informing them of what the law was?
So I mean, again, I think you could order or direct them to provide documentation to the building commissioner that they are operating lawfully. I think you could ask the building commissioner to investigate whether any additional enforcement was warranted at this time, but I think it'd be more of a request than like a remand.
So you talked about if this thing goes to court or there's some evidence that would be reviewed in a court proceedings, what form of evidence would it be? Is it a photograph? Is it some police log? Is it some artifact?
I mean, it could be anything. It could be testimony. It could be documentation. The limit on evidence for this type of review is that it just had to be something that could have existed at the time, that it was before you. Because this is the relevant time frame.
I have a question on so when the building commissioner says about being the boarding house, it has the part about the needing to be owner occupied. I get stuck on that because if this was any other boarding house.
So let me just make a comment. I think when I read what the building commissioner said, he says that he is using the definition of dwelling unit.
Right.
And then he says, our bylaw also has this other definition. But I don't see him as using that definition. So again, if this.
What was it?
So he says, based on this discussion, I'm using the definition of dwelling unit from the Stow bylaw, which reads as follows. This is attachment 8 to the application.
Mm-hmm.
And then in the same letter, he says the zoning bylaw also has the following definition of boarding house. And then after that, he says, let's see, the Stowe zoning bylaw really limits the number of persons who may live in the sober home to 5. And again, I don't want to speak for Frank, but I think what he was saying is, if they meet the definition of dwelling unit, they're a dwelling unit. If they meet the definition of room or boarding house, then that's what they are. So in this case, I'm not aware of you having any evidence before you that it's owner occupied. So it doesn't seem like they would be operating under the definition of boarding or rooming house, because it's not what they're doing.
Well, see so when I hear it, to me, I hear that technically they shouldn't be there because they're not allowed to be there.
Well, they can be there as a dwelling unit. If they meet the definition of dwelling unit, which is just 5 unrelated persons by blood or marriage in a single housekeeping unit.
But not as a boarding house.
But those are 2 different uses in your zoning bylaw. So it could be one use, but not the other use. And so if they are operating within the definition of dwelling unit, doesn't matter that you have a separate use that's a boarding house. They get to operate as a dwelling unit because they meet the definition of dwelling unit.
So that means then a regular person, not regular person, but like a house. I guess I'm questioning in our zoning what that means for owner occupied, because
There's no owner occupancy requirement in your zoning bylaw for a dwelling unit.
but there is for boarding house.
Yes, but a company could buy a single family house,
Yes.
owned by an LLC, and rent that house out to 5 friends who are not related to each other. And they can live together.
That's part of what Rec 5.
Yes,
Right,
so a sober home can operate in the exact same way.
now but if that's found by our building commissioner to be a boarding house, we wouldn't allow it in
Well,
a
it
residential neighborhood.
Well, but it wouldn't be a boarding house unless it was owner occupied. So if it's just 5 unrelated people, it's not a boarding house.
I
So
think,
you mean, wait a minute. I think, so if I think I'm following what you're saying.
So like if you and 4 friends want to rent a house together.
Yeah.
And cook together and talk about your days and share your meals and enjoy your lives together, that is a dwelling unit.
That's a dwelling unit, but then, I guess, because I do, like, there is a difference with people owner occupied in terms of a boarding house and somebody who buys a property and then wants to rent the entire thing and isn't there. And we differentiate between the two. And I feel like our zoning is picking that up, that there is, like, we have a difference to do, like, we want the homeowner to be in the property, running the boarding houses, the residential zoning, the way I'm reading it.
Okay, but there is a single family home, which is a single dwelling unit in your town.
That's what's typical for the boarding house, where it's like
But it's also, again, I understand what you're saying, but I'm trying to explain that if 5 recent college graduates can all go rent a house together, and none of them are related to each other, and they just want to live together, they can do that in any single family house in the town of Stow as a dwelling unit within that definition. So the same thing applies to 5 individuals living in a sober home together who aren't related to each other. They just live in the house together. It's the same.
Can you have a boarding house that's not a dwelling unit?
I mean, like physically?
Well, no, I mean, I can understand like having a dwelling that's not a boarding house. That's
Yes.
easy,
Yeah.
not owner occupied. Boom, then you don't have to worry about any of the other factors. But does the reverse hold true?
I guess I'm not sure I'm not sure what you mean by that, because it's not a function of the structure. So a boarding house in your bylaw is a building or premises, not a dwelling, a building or premises, other than a hotel, inn, motel, tour house, or lodging house, where rooms are let and meals may be regularly served by prearrangement for compensation. It's not open to transient guests, in contrast to hotels. So, it doesn't hold dwelling unit into that definition. Functionally, it seems like it would have to have some amount of like cooking, living, sanitary facilities, but.
I mean, maybe the difference is the single housekeeping unit piece.
No, I think that is the difference. I think
That's the difference. The
No, I
boarding house said you can be
Yeah.
strangers and not have anything to do
No,
with
that
it.
is, no, and that is the difference. Like I said, if you have 5 people that wanna live together and kind of function in a social living arrangement together, then, however you guys define housekeeping unit, that's the difference. So a boarding house is, I own my house and I have 2 people that live here and they come and go and we have no interactions and they just live here and sometimes you serve them meals. That is the distinction. If you have 5 friends or 5 people in a sober home that live in a house together and, however you define housekeeping unit, but at least to me, it seems like, share some meals, talk about your days, hang out with each other, function, together, don't live completely siloed lives. That's more like your definition of dwelling.
Does it make any difference how long they live there? I mean, like, if they're living there, say, only 30 days?
So I don't think that you can, I think if it crosses the line on what would really be a short-term rental, if that's something your bylaw prohibits, I think you'd be able to do it. If it's something the bylaw allows, which I'm not sure it does,
Quick question. Okay,
Yeah,
so
sure.
dwelling,
yes.
how's dwelling and dwelling unit related? Because dwelling definitely says not including commercial accommodations for transit occupancy.
So just to help you with that, so
Yeah.
the concept of commercial when you're talking about sober home is just irrelevant.
Okay.
So, because individuals in recovery are disabled folks and disabled folks have a right to live in the community.
Right.
So you can't apply something in your bylaw that basically would treat it as a commercial use, anything in the bylaw that would treat it as a commercial use as a way to prohibit it. The transient question is different, because if your bylaw doesn't regularly allow a dwelling unit to be used as a short-term rental, then the sober home couldn't be used as a short-term rental. But you would need, again, evidence. I mean, again, I watch the videos, it's not for me to judge, but, what makes this transient? And I think that has to be just part of your conversation, but, at the most basic, the fact that there may be a commercial component of a sober home is not a reason that a sober home could not be in a single family dwelling.
Right, and I understand that. Again, I'm just trying to understand
Yeah, so
how
to
dwelling
answer your
and dwelling
question-
unit.
Well, to answer your question, though,
Yeah.
in the context of a sober home.
Yeah.
That the commercial reference does not apply.
But has there been any precedent set, I guess, between a program that owns its property and a program that rents?
I don't think it makes a difference.
And there hasn't been any, because to me, and then that's what I was trying to say before, I feel like possibly that they aren't in front of us is a symptom of that.
But it doesn't make any difference, because it's not about the program, it's that the individuals carry these protections and the places that provide them the opportunity to live get the same protections as the individual.
Yes, but the individuals should get protection also, and if neighbors are complaining that there's over occupancy.
Well, that's a different issue of zoning enforcement. What I'm saying is, I'm answering your question. It doesn't matter, if you own the home and rent it out to someone who operates it as a sober home, or if an entity purchases it and they, tell them it doesn't matter.
Back to this issue of transients, I mean, how do we define transient? And if there is transients, does that mean that it's not acting as a dwelling unit?
So again, you have to treat the residents of the sober home the same as you would treat anybody else. So if your zoning bylaw doesn't allow short-term rentals, and you had evidence that it was being used as a short-term rental, you would apply equally and say you can't use this as a short-term rental either. There isn't a definition in your bylaw of transient. It only gets referenced 4 times. But
It doesn't discuss short-term rentals.
yeah, and it's silent on short-term rentals. It's not something I've delved into. It's not something, honestly, for these purposes, at least tonight, I don't think you really need me to. There's a whole other body of case law out there on short-term rentals. But
I'm still getting stuck on, but then wouldn't they not be allowed to be there right now?
why?
Because it says boarding house and we have an owner occupied. And that is not to say that program can't be owner occupied. I believe it can, but I think that's what I'm trying to get at.
Well, so it may not be allowed to be there as a boarding house, but it may be allowed to be there as a dwelling unit.
I think the challenge we have, and I'm permitting this case,
Sure, that's
we're
challenging.
not the only one.
Oh, no, it's challenging.
It's because a lot of the zoning bylaws in our towns were enacted before halfway houses became common. And so there's no specific definition for a halfway house. So what we're trying to do is take the issue of a halfway house and try to apply it to what aspect of the zoning bylaw most fits
Yes.
the halfway house. I think that's the challenge.
No, it's absolutely a challenge. You have to, you're very right. You have to almost not look at it with a label of sober. You have to look at it and say, how is it practically operating? Are there 5 unrelated individuals? Okay, so if you have, for example, 5 unrelated individuals or 5 people, and they're living in a single family home in a way that you think otherwise is a boarding house, as opposed to a dwelling unit, and that's a violation, then that's a different story. But it's not a violation of your zoning bylaw if the sober home is operating consistent with the definition of dwelling unit, that you also have a definition of boarding house.
Isn't it automatically a dwelling unit if you're living in it though?
No, it has a definition of dwelling, you have to apply the definition. So again, not every, place someone would live as a dwelling.
Okay.
So, yeah, we go back up to it all, it just goes on that page.
You had that up, right?
Yeah, I was just on a different page, let me get back to it.
Sure.
Oops, not sure. So again, a dwelling unit is 1 or more rooms for cooking, living, sanitary, and sleeping facilities, arranged for the use of 1 or more persons living together as a single housekeeping unit, but not for more than 5 persons unrelated by blood or marriage. As opposed to the boarding house definition, which talks about food sometimes being provided, and so it's a different use. They're just 2 completely different uses. It's like If you had, a nail salon and a bank, they're just two completely different uses.
I think this may have been already discussed at some point, or today or prior day, so I'm sorry if any of this is repetitive, but unlike other zoning enforcement decisions that sometimes come before us on appeal, where it could be someone saying, hey, my neighbor built a 85-foot structure on my property. That 85-foot structure is there on day 1 as it is on day 99.
Yes.
That is not the situation theoretically here. We've obviously received information that it's a very fluid situation, for lack of a better term. When we issue our decision, is it the facts as, I guess I'm trying to, is it the facts as of the date of the application? Is it the date of the decision? Or is it everything like during the time period? Does that make sense?
I mean, I think at this point, you had one hearing, substantively, and you should make your decision based on the information that's in the application and that you receive through that hearing. That said, if you make a decision and in the future, it appears that there's different facts or the operation has changed, I mean, it doesn't mean someone couldn't take zoning enforcement again later. It's not, depending on what your decision was. So again, for example, if your decision is, okay, we're comfortable with the law, and right now we do or don't see a basis for an actual zoning enforcement applying that law, it doesn't mean in a month or 2 months or 6 months, if something changes, there couldn't be a reason to take zoning enforcement at that time.
Could we even write in a decision that we are going to automatically review this situation, say in 6 months or a year?
That's hard because the board doesn't really retain jurisdiction. The board's ability to act is limited to specific applications before you, and you make decisions on applications, and it kind of closes them out, which again is why I say we tend to favor more like either ordering the applicant to confirm to the building commissioner that the evidence that they're operating lawfully, and then asking the building inspector to take further enforcement actions if they're not, or things like that. But you don't really have a ability to keep an application open. The law requires you to act within 100 days and make a decision.
But we might be thinking because of the special permits, where we can kind of go back and review, but that's specifically actually allowed for.
Oh, okay, so the dog
Yeah.
kennel was a special permit situation?
Yes.
We did that, we
Yeah,
had
so
everything.
like the annual review, for example, special permits is actually embedded within the bylaws.
Right, right.
So
they can be-
that's why it's a distinct situation.
Okay.
Because that category, we absolutely have the right.
Yeah, I was getting worried because.
No, understood. Yeah, yeah.
No, you can make, for example, a special permit renewable.
Yeah.
You can, require that somebody come back in a year or 2 years, or you can have those conditions. This is different because it's kind of like a yes or no that the building inspector get it right.
Okay.
So
Sure.
I'm going to read this comment from the MASH site that hopefully you can help me understand it then, okay? And it says, there's an opening paragraph and blah, 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 and it says effective September 1st, 2016, state agencies and their vendors shall only be able to refer clients to certified alcohol and drug-free housing. Any home not certified will not be able to accept clients from state agencies until certified.
Okay.
The essence of that is, in a sober home that's not certified, where do they get their clients from?
There are probably plenty of other, that only applies to state agencies, right? So not private hospitals, not word of mouth, not anything else other than state agencies. So I can't answer where they come from, but that is applied only to state agencies.
So in that context, the definition of a disability is whose discretion?
Anybody who is in recovery is considered disabled under the law.
Okay, thank you.
And to be clear, it's not specifically for housing. Like, it's the same for employment discrimination.
Yeah. No, I'm just trying to make sure I understand the filter here that is being applied.
Yeah. I'm sure there's countless case law on the definition of disability and how that's evolved, and honestly, how it's evolved over time.
Sure.
Well, the American Psychiatric Association has a definition and it applies to people with substance abuse. And I think when they passed the Americans with Disability Act, they use that, as part of the, what a disabled person.
I'm just reading from the building commissioner there. I think the part that I was holding on to is where it says secondly, 41 Birch Hill Road was built as a single family home. The proposed use is as a lodging house, constitutes a change in use. It goes on to say such and such. So you've given the two definitions.
Sorry, Maria, are you looking at the letter of the decision?
I don't think you're looking at the building commissioner's decision, I think you're
Oh,
looking at the
sorry,
request
sorry.
for zoning enforcement.
Yes,
Okay.
yes,
Yeah.
yeah.
Okay, yeah, so the building commissioner's decisions are just attachments 6 and 8, I believe, to the application package.
Okay.
Yes,
With regard to then that,
so that's a statement by the applicant, that's not the building commissioner, I believe. I don't believe, but what I have, I don't see that in.
oh, now it's right there, okay.
Does that help? Okay.
Any other questions for council? Thank you for taking the time. Any other?
Can an audience member ask town council? Probably not.
Yeah, no, I'm not here to provide more public information, I'm just here to help you with your deliberation.
We did close the hearing.
Yes.
Just on the enforcement issue, I know we went over it, I just want to make sure, we're clear, we issue a decision. I guess our enforcement is, we ask the building commissioner to enforce it, and if it's not enforced, we go to court, from what I can understand, just like any other decision.
Right, I mean, correct me if I'm wrong, but it's like if there's an order, the building commissioner is in charge with enforcing it, and then if that fails, then it's up to the town to decide, what it wants, what it wants to do, if it's risen to the level, or for the activity should take place, or whatnot. So, but Robin, correct me if I'm wrong.
Yeah, I mean, again, there's sometimes different avenues, but you certainly, in my opinion, could, again, you have to deal with the law and the facts here, right? So your decision may have different parts to it, but were you to, for example, uphold the legal notion in the building commissioner's decision that a sober home could be a boarding house or it could be a dwelling unit, and just as legal statements, and then, direct the operator to, essentially only use the structure within one of those, within one of those definitions, and direct them to provide documentation to the building commissioner that they are operating within those definitions, and you could ask the building commissioner to take any necessary further enforcement to ensure that they continue to operate, within those definitions.
And so in the commissioners, so it's basically both dwelling unit.
I think I can't speak to the building commissioner. I keep going back to them because I want to make sure I'm reading the language. So, yeah, I mean, I think the letter, you're right that there's maybe a little confusion in the letter because he says, I'm treating it as a dwelling unit, that's what I'm going with, but then he does reference the boarding house in here, and so certainly in issuing your decision, I think you guys could bring some clarity to that. You could certainly say, look, I think that a sober home could operate as either a dwelling unit or a regular boarding house. I don't think under your definitions it can be both at the same time because I think they're different uses.
Could it work as a bed and breakfast establishment?
Let's see what the definition of that is. I would imagine probably unlikely just because of the function of those, but I mean, let's take a look at the definition. So again, I mean, it's basically any kind of congregate living or familial living, so long as it's meeting the definitions that you have for those uses. I'm just moving it up here. I have a lot of definitions. I mean, maybe, I don't know, again, it starts to get pretty factual. You know, breakfast is included in the daily rate, you know, I don't know.
Right.
I mean, I don't know that a bed and breakfast is really intended to be like long-term congregate living per se.
Right.
I don't know, to
It
be
just,
honest, I mean, it kind of goes beyond the information that I have on this one.
when I look at it, it really, I think, to my mind, whether that's correct or not, is, it was, it fit more the transient, definition. And depending on how you define transient, obviously, but.
Any other questions for council?
Just, so in the MASH site, in terms of their certification process, they have a list of things that allegedly the certified provider should do. Would it be reasonable that we could ask the building inspector or building inspector to kind of look at those things and say, you know, does it meet this criteria or?
In my opinion, no, because they're not requirements of your zone.
Right, they're not even, you don't even have to comply with them to
No.
get certified.
So no, I
Yeah.
mean, they're not, again, you're under zoning, you're treating this like
Yeah.
a comparable use, and you wouldn't ask a comparable use to certify that they were operating within any kind of standards.
So how do you collect empirical information to know that they're operating as stated?
Again, I think that's where you could order the operator to, you know, within a period to provide documentation to the building commissioner affirmatively that they are in fact operating under whatever definitions you apply, and ask the building commissioner that to take any additional necessary enforcement if the building commissioner doesn't get that information.
If it were, just thinking like in terms of the city with occupancy, if people are making complaints on something's over occupied, such, usually it's the Board of Health that comes in to inspect, correct?
I can't say, I mean, I think again, it would depend on if it's a zoning violation, it would depend on
Well,
if it was a Title V violation, like I don't know, I can't answer that because I don't know.
that's what
It
I'm
would
saying,
depend on the nature of the complaint.
so over occupancy.
But I don't know, I'm not trying to I don't know what over occupancy means, right? Like, so, over occupancy under what laws?
So there was a unit and that they are under the belief that 20 students are living in it.
So then that would be zoning. So you would go to your building commissioner. Would investigate that.
Okay.
In this town with bylaws, I think this also, just to slightly related too, is that I think it's currently seen as best practice to not have discussion of blood relation in zoning bylaws.
Oh, yeah.
So I think, you know, in the future, we may wish to remove that language in order to comply with fair housing.
That's a topic for another day.
Yeah,
It's not that topic.
it is a topic, yes, it is that is a topic for another day. You know, again, if a complaint is received by the town, ordinarily, you try to get it directly to the right, you know, town employee or board or commission that handles whatever the factual basis of that complaint is.
It limits to 5 people, 5 unrelated people.
Yes.
One of those would be a manager with 4 others.
I don't know how they're operating.
Oh, okay.
Yeah.
But is that financially feasible? Do we have to take that into consideration? Can we deny them even if they say it's not financially unfeasible to have less than 5 people? They need 8 to make it financially viable.
So just to clarify, when you say financially feasible, you mean for them or
them? For them.
Oh, that theoretically they could come back and say, well, the conditions you've imposed on us are so burdensome,
Right.
then we're gonna go bankrupt. And something like that.
Again, a SOBRM has the ability to ask for reasonable accommodations if they think that your zoning is being applied in a way that you know, they warrant a reasonable accommodation. I'm not aware of them having asked for that.
I was gonna say,
Or even
but they
engaged.
have to ask. We can't,
Well,
it's not our obligation.
It's
Yes.
there is an obligation to have a cooperative
Yeah.
community conversation about that, but given that no one has participated or provided you with any information, I think there would have to be, some direct contact with them. But again, you do have an obligation to engage on that, absolutely, and cooperate in that. Not necessarily to grant it, but to engage in good faith in the conversation about it. So
Right.
again, in the Bach case, for example, they did, the Bach case was a 3-family, so they had people in all 3 units, and they did give some kind of like adjustments of how many could be in each unit because it made more sense for their operations. And that was an accommodation that the board granted. But it's not for you to have an opinion about whether or not how they're proposing to operate is financially viable, just like, no, I mean, but just like, again, if somebody bought a property and said, hey, I'm gonna try to rent this out and cover the mortgage, it's not up to any of us to say whether that's a good idea or a bad idea.
I think one of the things that I just worry about is just if I guess it depends on neighbors for the program could also be running irresponsibly and it could be a health problem for if it's the neighbors that are saying, oh, there's too many people living here. Does that make sense? That responding in the same way we would if it was any other 5 students, if that makes sense.
I mean, you treat it the same as any other comparable living arrangement.
Okay, that's, yes.
Yes.
Okay.
One of the things that's been brought up multiple times is the fact that we've received limited to, I guess, essentially zero information or communication from the owners, the owner of the property. So what I'd like to do is ask town staff yet again, has the town had any contact or communication with the owner or any representative of the owner since the last meeting?
I attempted to call the applicant and I did not get through. I believe the building commissioner was able to talk, or not to the applicant, to the property owner. I believe the building commissioner was able to talk to them.
Nothing in writing though.
But we haven't gotten anything in writing, so.
So when you reach out, willingness to provide us any information or? I'm sorry.
No, I'm sorry. It was I misheard you. It was garbled. I didn't hear what you said.
Yeah, I'm sorry. Did they indicate a willingness to provide us with any information or I realize we closed the hearing, but would they be willing to come before us if we reopened the hearing? Did they indicate anything of that sort?
I'm not quite sure we can go into the substance of anything they may or may not have said without reopening the
Are we
hearing.
getting into some?
I'm not aware that they've made any requests for you to reopen.
Okay.
So when we reached out to the owner, what, did we have a question that we posed, or was it just a, how do you do, or are you gonna come and see us, or can you respond to that?
The call that I made was to make them, just to try again to make them aware of the permit process that's happening and present them with the resources as to see the materials submitted and the video recordings.
Okay, thank you.
But they then had, sir, I'm sorry.
Yes, Mr. Chair.
But there was a substantive communication between the building commissioner and the owner's representative, verbally.
From my understanding, yes.
Is that something that could be shared with us in our?
So again, factually speaking, your public hearing is closed, and I think the important thing is that I think it was important for the board to have a comfort level that the property owner knew this was going on, and it sounds like they did.
If they know what's going on, okay.
But procedurally, we could reopen the public hearing on our own accord in order to learn what was discussed during that conversation.
I mean, you could choose to reopen the public hearing, you would need to repost notice and publish. If there was a reason to do it anytime until you file your decision, I just remind you to keep in mind the 100 days.
Number of days.
Right, understood.
Yeah,
And Michael, remind us, the 100-day deadline would be?
April 9th.
so, I mean, again, you could, put it on for a couple weeks from now, if you wanna be able to reopen it, if you wanna be able to have comprehensive conversation, publicly, that's your call. It would just need to be, our position is that the proceedings aren't done until the decision's filed. But, once you close it, in fairness to folks, if you're gonna reopen it, you should do a full noticing, posting, publishing, so everyone's aware.
Understood. Then we want to discuss that or not?
Yeah, I had made a motion in the previous meeting that we reopen the hearing, and I'd like to make that motion again, based on some new potential information.
We have a motion. Do we have a second? Can I second?
You can say.
I'll second. All right, we have a motion, we have a second. Is there any discussion with respect to the benefits or disadvantages of reopening the hearing?
What do we think the new information will be?
Well, I don't know, I feel like we're operating in the dark and playing like a quiz show in terms of, what happened, what the communication was. I'd like to be able to see it, and it might be useful to have that information presented to the public and have the public respond as well. I mean, I understand that the board didn't, when I made the motion previously, the board didn't feel we needed to go there, but in light of this development, I would ask you to, review that, reevaluate that, because I think it would be beneficial, and I think we would be better informed, and we wouldn't be. I feel like I'm operating in the dark. It's like a game of Clue. I'm trying to find out, and I'm trying to, get the information, and I just think it would be helpful all around. I don't see what the harm is, as long as we do it in a timely fashion, so that we don't run into the deadline.
No, of course.
Yeah.
So there's a high probability that the owner won't show up or respond. And the only evidence that we think that's new at this point would be some discussion that's been conducted between the town and the owner, right? I think, I don't know.
Correct. To the
There
extent
doesn't seem to be any other data points that we might have access to or be revealed at some point.
right, it's to the extent that the owners have made any representations to the town, whether that would want to be, whether that would be considered, whether it be a plus or minus, however it might be.
I still think it'd be valuable to know that, even if they're not going to show up, just to find out, where their thinking is anyway.
Frank, in his decision, told them how they have to proceed. He told them it's either a dwelling unit limited to 5 people or a special permit. And it's up to him to enforce it, whatever way they choose to go. If they don't want to come in with a special permit, then they have to occupy the house with 5 people. That's his choice to improve,
Adjudicate.
Yeah, I guess I'm not obviously voting on this one, but it's obviously, is there, I guess everyone needs to make a decision whether or not you think there's gonna be substantial information that will change your mind on this. And, there obviously has been no action from the building inspector based on that conversation. Therefore, is there information there that would likely change your mind as to what needs to happen?
I still think it's up to the building inspector to follow through with his letter, and if they don't respond, then it's his up to enforce it that there's only 5 people living in the house, including the manager.
I think it's always good to know,
But we can't force them to do anything.
no, but I think it's always good to know what their thinking is, even if it's not going to, at the very least, in terms of how we frame our decision and what our approach and strategy is. It's good to know what what their thinking is.
I don't know if we have any strategy other than to, read the building commissioner's decision and, either agree with it or disagree with it.
Well,
Whether they, the persons that own, Birch Hill's home, want to, communicate with the town of Stow or not is not our, we don't have any say in that. And what they say means nothing to us. They need to apply if they want to go over 5 people.
I think whatever decision we make, I think anytime we make a decision, we have a strategy in terms of how we approach that decision.
I still feel like I'm missing, like, I still don't understand why that owner occupancy piece doesn't
Okay.
come in.
So I'm not trying to cut you off.
Yeah.
I'm trying to keep the discussion to just the motion that's pending, which is just a motion to whether or not we want to reopen the hearing or not. And with the need to notice and whatnot, that would be on, just to give people context what they would do.
The earliest would be the 23rd,
Monday.
but it would likely need, now I'm just,
Before
I'll
you,
have to double check with the paper. to make sure
so we could post it, you mean, so that we could actually legitimately have a meeting open, a meeting with
Right.
everyone here?
So I
I
would-
mean, yeah, that's what I was gonna say. We got 30 days effectively to get through the loop and commit to the 100 days, right?
It could get renoticed to be on April 6th, which is the next meeting, which would give us enough time if the paper's not running 1 week.
But we have to make a decision by April 9th, though, right? That's the deadline.
Correct.
Yeah.
That's kind of close.
So
I mean, I would think we would have to do it sooner, I don't think we want to
Right, there's a gate here, and there's some logistics to get the thing to occur, and by the time you get it posted and have everything turned around, you're gonna be running up against the time constraint.
it could be the 30th as well, but because the paper's on Fridays.
Did you say the March 23rd would be possible or not possible? Is that too soon?
23rd would be if the paper is running the 6th and the 13th in print. If not, it would be like the 13th and 20th would be running, so that would be the 30th.
Oh, so we don't know.
I would need to confirm it.
Is that the only communication vehicle that we have? Once the paper went out of business, what do we do?
That's fine.
You have to
Find another one.
Okay,
Yeah, it has to be a paper
it has to be a public
circulation,
search.
yeah.
I know in the past, we've used the Metro West News, I know in the past.
It just has to be something that's in circulation.
That's fun too.
Telegram.
Has to be
Metro
printed
West News.
circulation, not online. Yeah.
Yes, we've been looking for alternatives to
The Globe.
It's-
In Metro West, I would never buy Metro
It was
West.
They don't print anymore.
The Globe is the Globe is $900 a posting, so we don't have the budget to rely on the Globe at this point unless
Interesting conundrum.
$4 a month for the Globe.
so.
Okay,
So-
anyways. Any further discussion on the motion to reopen the hearing? No?
I like the idea of them having more time, but logistics.
Well, any further discussion?
It's a majority vote, sorry.
Yes, it is 3-2.
Yeah, majority.
Yeah, all right, all in favor of moving to reopen the public hearing, say aye.
Raise a hand.
Okay. All opposed? All right, 3-2, motion passes. So the public hearing will be reopened. And we will have to set a date for that.
If we don't know, I would say probably March 30th, because at least that would give us enough time to publish. It still gives us enough time for the April 9th deadline.
I mean, we could do, is,
So because you're not actually continuing today, like you don't have to announce a time, place and date certain because you're gonna posted, so
That's right.
Michael could confirm if it's the 23rd or the 30th, if it works for you folks, but
Just to double
It's
check,
different
is
than-
everyone available on the 23rd and 30th?
I'm not going to be, but I don't.
Well, you're not. No offense.
That's it.
You're more than welcome to.
Miss Owen?
We'd still like to have you here.
Yeah.
Yeah, right now, I'd say yes, David, so unless something else changes, my calendar is open.
I mean, if possible, I would say the 23rd is better because I want to have enough time.
Yeah. Make that work, that sounds like a good strategy.
Okay. Now, the only thing with March 30th, I may be away, but I could do it by Zoom.
That's fine,
Okay.
as long as you're in attendance.
In fact, it may be the same for April 6th as well, but I'll do it by
That's
Zoom.
fine. My intention as chair would be to try to push this as far as we can on the next meeting, public hearing and everything included. And so, and I'll note to the applicant, for the public hearing, I know at a minimum, there are some documents that I think you had intended on submitting that, hadn't been submitted on time. And so that opportunity would be open to resubmit those at that time.
Yes, I believe that, before the ZBA staff, and I welcome the opportunity, presented and provided to, not submit so much additional evidence, although I do have the certificate of incorporation in Delaware now. But, just to address some of the legal points that I've heard discussed the last couple of weeks.
My intention, and I'm not trying to cut you off,
I'm not gonna-
improperly, I just want to make sure that we keep things in line. My intention as chair would be to provide obviously you as applicant, with an opportunity to comment from the board, but it will be limited. So I'll only.
I'm not gonna go on like. Now you focused me in on what's, important.
Excellent.
Thank you.
Okay, thanks, sir. All right, before, well, I guess, anything else with respect to 41 Birch Hill Road? No. Okay. Okay, so, thanks to council, for being here for that. Okay, so with that, the only other, well, we have two other administrative items. We do have the minutes of February 17th. I am not opposed to having folks, because
I'd like some more time.
that's what I was gonna say, because of how substantive it is, I'm not opposed to having folks taking the opportunity to review it and placing this on the next agenda, so we can, otherwise, to be perfectly honest, if we're gonna have to go through this on the fly, we could be here for the next hour, and I don't think that's a good use of staff's time and the public's time
Can
as
you
well.
make that available electronically?
Yes, I'll send it out,
Okay, great, thank you.
for tomorrow.
Excellent, okay. So we'll place this on the agenda. There was also one item of correspondence that was on the agenda. If anyone has anything they want to discuss to it, I'll open to it, but if not,
Correspondence involving,
myself and the town administrator.
yeah, could we have a discussion about that?
Sure. What would you like to discuss?
I'd like to know what's going on.
That
You saw the note?
I don't have anything else to add. I did have a very productive conversation with Valerie, and I think we left everything on very good footing after that. I have not communicated with the town administrator largely because she was out of town and I was on a flight today. But everything I think I've said everything I had to say in the email string.
Well, my understanding is that we have a meeting with the select board.
I'm not aware of anything. I'm not aware of any actions been taken since that email string. So
we
at this
don't
point,
have, we don't have a meeting with the select board.
nothing has been noticed.
Nothing's been noticed.
No.
Okay. Something would have to be noticed by,
Well, it would be put on the
well, within
agenda.
48 hours.
Yeah. So, but I don't have anything to add.
Nothing to add. So we don't know whether we have a meeting with the select board next week, is that correct?
That is correct.
That's your assessment?
Yeah,
Is it true?
sitting here today at 8:53. Yes.
Okay.
Anything else?
Yes, I didn't like the tone of her pushing her memos there.
I don't know how much we can discuss. See, that's in an open meeting. That's my trepidation here. I mean, there are plenty of things I'd like to say about it. Well, I can say in general. I'll say something in general. If people on a board act within the scope of their board responsibilities, they are not liable to be sued personally. And to be beyond the scope of something, within their board responsibilities I would say it would be a very high bar to cross, to the point of, wanting to murder somebody practically. I mean, it would have to be something really seriously intentional. And so I was very surprised at that comment in general.
The only other thing I'll say is that I'm sure it's the intention of every member of the board, as it is mine, member and associate member, that we are acting in good faith as best we can, and that we'll continue to do so.
And if I can add another comment, I have known these people on this board for quite some time. I think I know them quite well, and I don't think any one of them would have, not even an inkling would there have been a chance that any one of these board members would have acted in such a way as to commit some kind of intentional illegal act.
Is that what I'm missing now?
Pardon?
I missed something.
What's
Okay.
Oh, you don't know what this is about? Okay. All right.
Any other comments?
And I'll add one more thing. 35 years in this town, having served on several boards, I would say the same thing about every board I've ever served on. Anybody that's ever volunteered their time for this town, none of them would ever have done something that would put them in a situation where they would be personally liable because they advocated doing something illegal intentionally.
Anything else? In that case,
I would just say this, thank you for your response.
all right, with that, I'll entertain a motion.
I make a motion that we adjourn the meeting at 8:55.
Second.
We have a motion, we have a second. Any discussion? Hearing none, all in favor?
Aye.
Meeting adjourned. See everyone in a few weeks.